Hi everyone. The federal suit got stayed pending the outcome of the state case. Basically what this means is that they didn't want to answer the complaint, so they got the federal judge to hold off on the lawsuit until after trial. Now I've got 45 days after trial to reinstate the lawsuit or it gets dismissed. I'm willing to bet they're planning to keep me in immigration detention for every last one of those 45 days. Will they figure out that the tribe I'm from, I'm Cree Indian by the way, traditionally extends from Quebec to Montana and as far south as Missouri. I posted proof of me being American Indian on Facebook. Also on Facebook, and on public record in the courts now, are the following highlights from the state proceedings, none of which the judge found to be a sufficient showing of bad faith to stop the state court fiasco. Number 1. The rapist's brother was allowed by police into the house to run the dishwasher after the police saw my post on Facebook about being drugged and sexually assaulted. This evidence, namely the drug residue in the glass I drank from, would have proved involuntary intoxication. This is shown by A. Photos of the dishwasher on May 13, 2013 with no clean indicator light on. B. Clark Police Department Detective Diaquino's report admitting the rapist's brother was at the scene on May 14th. C. Union County Sheriff Officer Gardner's report on May 15th stating that evidence has suddenly appeared of the dishwasher being run. To prove they knew that they were wrong, I put in the lawsuit Clark Police Department officers Meehan and Akabu's reports, which both hide the fact that the rapist's brother was in the crime scene on May 13th and May 14th. The rapist's brother slipped up when giving his statement, which I posted on Facebook along with the rest of those reports, and he said he was securing the scene on May 13th. Number 2. The bottles and cups that were actually collected were rinsed with fresh water by the crime lab without testing for drugs. Considering the head investigator, Theodore Romancow, admitted to the press that he knew and was friends with the dead rapist, I'm frankly not surprised. This also explains why the investigators under his command were instructed to only collect evidence damning me, but to ignore evidence of the rape. Number 3. Here's some logic for you intelligent and conscientious observers. On page 7 of the November 13th, 2013 grand jury transcript, which I posted on Facebook, the prosecutor says, and I quote from lines 22 to 24 of page 7, he says, "It doesn't appear that Kai showed any signs of being raped. There is a rape kit done on Joe. No semen was found." That's Assistant Prosecutor Scott Peterson right there. Consider his statement, that I didn't show any signs of being raped. He backs that up by the rape kit done on the rapist. What the fuck? But then he says, no semen was...
This call may be recorded or monitored.
I challenge you to look up the lab report I posted on Facebook. You will see that the rapist's own semen, along with traces of my blood, were found on his penis. Involuntarily intoxicated people cannot form consent. So consider Scott Peterson's bald-faced lie for what it is, and read his statement in the light of truth as such. It does appear that Kai did show signs of being raped. There's a rape kit done on Joe. Joe's semen was found, along with Kai's blood. Out of his own mouth, Scott Peterson admitted that they knew I was raped. Number 4. Let's back up to that rape kit. You know it should have been done. I know it should have been done, and I got them on record admitting that they knew it should have been done. Here, a quote from page 92 of the grand jury transcript, from line 2 to 13. "And part of your investigation is because of these allegations that Kai put out there, you have to follow up on it. And some of the things that he had said, he had been date raped. And he said he believed he was drugged by Joe Galfi. And Dr. Pandino was basically briefed on the facts of this case." Whoa, hold on a minute. Robert J. Pandina is not and has never been a medical doctor. He is a pop psychologist who works at the Center for Alcohol Studies in Piscataway, New Jersey, and he is not even licensed to practice psychology, much less medicine. Since I'm quoting stuff, let me quote the law. "Any person shall be regarded as practicing medicine who shall use the words or letters DR or doctor in connection with his name, and who holds himself out as being able to diagnose any human injury or physical condition." That's NJSA 45:9-18. So, the prosecutors knowingly got Pandina to break the law by practicing medicine without a license, knowing and admitting that they had a duty to bring me to a medical doctor, knowing full well that a rape kit and drug test should have been done on me. Number 5. I should point out right now that the rapist's brother was the chief of police for 30 years. He blurted out in a statement I posted on Facebook that the rapist brought a vagrant to his parents' shore house back in the 1970s, but that vagrant got charged with robbery. So how many others were there that got threatened with a robbery charge if they didn't keep their mouth shut? The rapist had the head criminal judge on speed dial. Seriously, I pointed this out in court earlier this year and made the newspapers, but they didn't see that as a good enough reason to change counties. Any vagrant who spoke up would have gotten their ass nailed to the wall. Number 6. So they broke the law by helping the rapist prevent vagrants for 40 years. They broke the law by tampering with evidence. And they broke the law by the unlicensed practice of medicine to cover their tracks. Then they lied about it in court and slandered me in the media. Yet none of this was a sufficient showing of bad faith. What the fuck?